We're going to make a start now, everyone. Thank you for joining. Welcome to the webinar. The topic is Do No Harm, Mitigating Human Rights Risks when Interacting with Medical Institutions and Professionals in Transplantation Medicine. We're going to discuss a world first leading advisory report that's been authored by Wayne Jordash KC, and it sets out the international legal responsibilities of medical institutions and their professionals to avoid complicity in hidden mass atrocities. Just some housekeeping. If you wouldn't mind keeping yourselves on mute, and we're going to record the session, but we won't record the Q&A, so don't worry, none of the audience will be recorded. If you have a question, please could you pop it in the chat, and I'll make sure I get to it a little bit later on after the panelists have all spoken. We have a fantastic panel today. Everyone has interesting things to say. Time is tight, so I'm going to keep an eye on the time. I'll briefly introduce the panel. I know everyone's probably read their bios already. So we have Wayne Jordash KC. He's a well-renowned international human rights and humanitarian law lawyer. He has an exceptional practice, and we're extremely grateful for all the work that he's done with us at ETAC. We then also have Professor Natalia Schlabowska. She's the chair of the Australian Lawyers Human Rights Business and Human Rights Subcommittee. She's a professor in law, and she's an expert on modern slavery. Welcome, Natalia. We also have Professor Penelope Weller. She's a professor in law as well at RMIT University. She's an expert in health law and mental health law, and she's published extensively on the subject. And then we're very lucky to have Dr. Maria Jovanovic as well. She's a lecturer at Essex Law School and Human Rights Centre and has a focus on human trafficking and modern slavery, especially in the context of international business, trade, and global value chains. So thank you all for joining us. It's very much appreciated. Thank you for taking the time. So without further ado, I pass over to Wayne to tell us more about the advisory. Thank you, Wayne.
Thank you, Ellie, and thank you everyone for attending to listen to our commentary about the legal advisory and policy guidance. I'm really hoping that we can have a real discussion amongst the experts today on these issues. I think there's lots to be learned from those who are part of this panel. Let me also firstly say, whilst I appreciate Ellie saying the report was done by me, I want to note that Lara Strangeways, who's the head of our business and human rights, and May Prantle, who is one of our advisors, were really critical to the work within the advisory and the policy guidance. Their thumbprints are on every page, and so I wouldn't want to take credit for their work. Let me now turn quickly to the legal advisory and the policy guidance and what we were trying to achieve with these documents. First of all, we started looking at these issues because it became apparent to us from open source research that in a number of countries, medical institutions, hospitals, essentially across the whole transplant industry, there were many partnerships and much activity being done without any apparent cognizance of the human rights risks, and as a consequence of that, or at least in part as a consequence of that, without any due diligence being conducted which could in any way meet the challenges of these human rights risks. And so we started to look at this open source research and then embarked on a 6-month deeper dive into the transplant industry to have a look at what the human rights risks were within the transplant industry, and critically what was being done about them within the industry, if anything, and what should be done in light of what we found to be obvious risks. And so the advisory was an attempt, or is an attempt, to raise public awareness within the industry, but beyond the industry as well, amongst such policymakers, parliamentarians, think tanks, international organizations, and of course, critically, amongst international lawyers and lawyers as a whole, to raise awareness essentially of what are real systemic problems within the industry, and the gargantuan amount of work that needs to be done to meet the risks that exist in terms of both soft law and hard law. And I'll come to that in a minute. And we deal with that extensively in the advisory, and we also deal with it in the policy guidance. As you'll see from both documents, the advisory is much more of a discussion document, outlining risks, outlining what the state of play is within the industry, but also how those risks can be ameliorated. And the policy is much more about concrete steps that different parts of the transplant industry could and should take in order to meet these challenges. So just very quickly, what are the human rights risks in transplantation medicine that we deal with in the advisory? Well, we elaborate in detail about essentially a sliding scale of risks. On the one hand, what we referred to and what is referred to as transplant tourism, which is at the softer end of the risk. But when I say softer, I'm not trying to diminish those risks, nor the human rights violations which occur as a consequence of transplant tourism. It's a big industry. It accounts for 10% of the world's transplants, and is a lucrative industry with annual revenue between $850 million US to 1.7 billion US dollars. What is transplant tourism? Well, it's essentially part of the industry which essentially involves the exchange of organs for money. And according to the World Health Organization, it essentially undermines the key principles of ethical organ donation and transplantation, namely voluntary and informed consent. For the World Health Organization, organ transplantation of this kind lacks the kind of willingness and free exchange of organs, or free giving of organs, essentially because it consists of exchanges which involve undue influence and or coercion. So that's the, if you like, the softest end of the human rights risk scale. And you travel through organized crime of organ trafficking, which you might consider to be in the middle, and then the top scale, which consists of state-sanctioned regimes where organs are forcibly removed from executed prisoners and prisoners of conscience, as in the People's Republic of China. So the advisory looks at this scale and asks certain critical questions about what the industry is doing to confront these risks. We do have a focus in on China because it's worthwhile, and it's also quite instructive. For those of you who are unfamiliar with the organ system or organ transplantation system in China, it's worthwhile having a dive into the advisory. There are strong indications that there is a state-sanctioned regime of forced organ harvesting, beginning around the early 2000s, when China leapt from being a follower to a leader of transplantation technology, despite there being no voluntary donation system. Within a few years, the country made impressive developments in the field of transplantation, and these developments have continued, moving from surgery, which focused on only kidney transplants, to now hearts, lungs, and livers. And moreover, these strong indications include transplants being able to be planned well in advance with specific dates on organ availability, able to be communicated to the intended recipient well ahead of time. Obviously, these are serious red flags. In 2009, China stated that 2/3 of all organs used in transplantations were removed from death row prisoners, but asserted that prisoners had consented. Also, that admission did not appear to lead to any change in terms of the practices, in terms of the red flags. It also continued to correspond to a crackdown on Falun Gong. For those of you who are not familiar with Falun Gong, it's a spiritual practice rooted in traditional Buddhist and Taoist teaching. And they've been subjected to a system of, well, a campaign, I would say, of crimes against humanity, which involved disappearances, extrajudicial killings, and other grave human rights violations since around 1999. And the progress of the Chinese transplant system has corresponded quite disturbingly with that crackdown. Probably you've heard of the China Tribunal. This may constitute one of the best indicators or certainly the most extensive adjudicative process into these issues. And they found that essentially there was proof of a campaign of crimes against humanity established beyond reasonable doubt, and part of that, or a large focus of that, was the forced organ harvesting from Falun Gong. I won't go into much more detail of that, but it is important to look at these issues, and we do so in depth in the advisory, because in a sense, there's such a clear indication from this evidence. And it's important as a departure point then to look at what's the response of the transplant industry to these clear indications of serious gross human rights violations being connected to the transplant industry, at least in China. Well, the answer to that is not terribly edifying. If you look across the industry, there is a general complacence at best. At worst, actually, there's a closing of the eyes to the obvious. For example, international transplantation societies such as the Global Transplantation Society regularly interact with Chinese transplantation professionals as part of academic conferences, professional development programs, and so on, without any indication of due diligence. Pharmaceutical companies enter into joint ventures with Chinese companies to carry out research and trials into new immunosuppressive drugs, and are granted exclusive distribution licenses in China, again, without any indication of due diligence. And I could go on. Several studies carried out by bioethicists and other researchers have shown that well-known medical journals have published numerous research articles by Chinese medical professionals where it could not be ascertained that the donor had consented to having their organs removed or used for research purposes. And so this is what we discuss at length in the advisory. We touch upon the type of links that could give rise to legal consequences. And we touch, of course, on the wider issues of partnerships and activities being linked in a more remote way to these types of human rights violations. And so what we also try to do in the advisory is to set up or describe how the transplant industry should be confronting these risks. We looked at the soft law framework of the UN Guiding Principles, of course, and we also looked at hard law requirements under various domestic laws in Australia, New Zealand, the US, Canada, France, Belgium, the UK, and also on a broader European and EU level. Now, we discussed some of these this growing web of regulation and laws. We, of course, were focused much more on the dimension of cross-border relationships in organ transplantation. We of course, couldn't look at everything. There's a vast array of protocols and regulations in each of the countries that we looked at. But we've, as I say, narrowed in on the focus of cross-border relationships and looked at, of course, what under the UN guiding principles should be done by institutions, individuals, and the industry as a whole. Human rights policy statements, of course, how to develop, implement, and evaluate minimum human rights due diligence, and remedies and remediation. And we hope that the policy guidance, as I touched on at the beginning, is a good tool, at least a departure point tool, so that those within the industry who are not familiar with this soft law or hard law can start to think seriously about their responsibilities and take action accordingly. Just very quickly before I stop, there's been a number of developments since publication of the advisory and the policy guidance. You will probably be aware of the EU Parliament at the beginning of May of this year adopting a resolution on the continued reports of forced organ harvesting in China, in which it acknowledged that forced organ harvesting in China may amount to crimes against humanity, and called on relevant institutions in member states to evaluate and revisit the terms of their collaborations with Chinese institutions on transplant medicine research and training. The UK has passed the Health and Care Act recently, which amends the Human Tissue Act 2004 and adds extraterritorial offences under Section 32A for commercial dealings in organs carried out in China or other countries. There is, and I won't belabor the point, I hope we can discuss it in the next 40 minutes or so, but there is a growing awareness, at least on the national level, even if not within the industry, that these practices need to be better regulated. And what we hope, as I say, to do in the advisory and the policy guidance is to try to drive that change within the industry. There is movement, but there needs to be much more movement. So let me pause there and open the discussion up for other panelists. Thank you for the time.
Okay, thank you so much, Wayne. That was brilliant and clear. Yes, we'd very much like to hear from the other panelists. So perhaps, I think if Natalia, Professor Natalia Jordash, would you like to make some comments first?
Thank you so much, Ellie, and thank you, Wayne. That was really excellent. As Ellie has already said, I'm speaking predominantly today on behalf of Australian Lawyers for Human Rights, which is a non-governmental human rights organization in Australia, one of the biggest ones that comprises legal professionals, law academics, and law students and graduates. But before I move any further, I just would like to acknowledge and pay my respects to elders past, present, and emerging, and honor the cultures and histories of Australian Indigenous peoples who are the traditional custodians of the land on which many of us today participating in today's event are based, which for those of you of the participants that might not be familiar, that is a protocol used in Australia to pay respect to Aboriginal and Torres Strait Islander peoples in Australia. Now, very briefly, because I think it's important to put it into context in terms of how transplantations, especially illegal, potential for illegal transplantation, organ transplantation might come about in the context of modern slavery. So we have been involved in the development of modern slavery legislation in Australia, and just a quick side point for those who might be less familiar, Australia has currently 2 acts, Modern Slavery Act 2018 at a Commonwealth level, but also in the state of New South Wales, so at the state level. And since the inception of this development, we've been involved with other organizations, including ETAC, on advocating for the inclusion of organ trafficking, and in particular the illicit removal of organs from living or deceased persons, and the solicitation of commercial organ transplants in the modern slavery legislation. To some extent, it has been successful. in a sense that the Modern Slavery Act in New South Wales makes a reference to Section 32 of the Human Tissue Act 1983, which prohibits trading in tissue. Now, with this example, I just wanted to highlight the difficulties in relation to legislating matters in the context of organ trafficking, not so much within the national jurisdiction, but when it comes to transnational issues. And so just very briefly, and I'm happy then during our conversation to touch on it in much more detail, provide a bit more context in Australia. But what I think is important here is that during the public consultation, a number of reservations have been made in relation to even including that reference, including by the government, the New South Wales government. And the basis of it was that New South Wales Health imports blood-related products, particularly plasma-derived products from different parts of the world in different countries that do allow for donors to be paid for the donations, which potentially would be in breach of Section 32. And consequently, what you will find in Modern Slavery Act in New South Wales at the moment is reference to Section 32 that is prohibiting trading in tissue, however, only when that tissue is an organ. So I think it highlights the difficulties that Wayne also touched on, which is that even when we have national legislation that it's attempting to deal with organ trafficking, and again, that is also contextual in the sense that what is regulated within Australia. So anyone, a donor being brought in or moved into Australia, that would be considered to be trafficking offence. However, for Australians to travel overseas, would Wayne mention the transplant tourism, to purchase an organ, that would not be criminalised by itself. So even when we have laws, national laws in place, they might not necessarily be compatible with laws elsewhere. And so that's why it's so important, and advisory really highlights that issue of global cooperation in this space, in a sense that legislating at national level is very important, but we still need that international global engagement in the subject matter, because otherwise we're always going to find that there are going to be gaps, and the gaps will be used, and those gaps will be exploited. Now, I'm pretty sure that we are going to touch on much more on how that can be regulated in the context of business and human rights, but I'll leave it to other speakers to touch on it, and then I'm pretty sure we're going to have a more in-depth conversation about it altogether. So I'll pass it on to Maria now.
Hi, good morning, everyone. Thank you for having me. I will just briefly introduce myself and say a couple of words reflecting on the legal advisory report and policy guidance. And I'm just happy to answer later on any questions that you might have. So my name is Maria. I'm here on behalf of the Essex Law School and Human Rights Centre, one of the world's oldest academic and human rights centres. I have to mention we are celebrating the 40th anniversary this month. My own research focuses on modern slavery and human trafficking, and it looks at the way this phenomenon intersects with different legal regimes. So the advisory and policy guidance address important issues and raise critical questions that require attention, in my view, by international community and individual stakeholders. They illustrate pretty well a growing demand for organs, which has unfortunately resulted in a series of unethical and, in many cases, illegal practices. So the documents then explore, as Wayne said, the legal ramifications of relationships with medical institutions and professionals who may engage in such unethical organ transplantation, organ trafficking, or even forced organ harvesting. So my understanding was that the key goal of both the report and policy guidance is to explain how the existing legal rules apply to such practices, and more specifically, implications for the private sector here. So in other words, the goal was to flesh out rules of international and domestic laws that apply to those that engage in such practices, and I believe also to identify gaps in the current regulation or in the implementation of the existing rules. So I think what's really important is when the report and policy guidance speak about, for instance, phenomena such as forced organ harvesting, which amounts to crimes against humanity, given the audience it primarily targets, I think it's very important to unpack these terms and make them palatable to non-legal professionals. What do they mean for a specific company, organization, and individual? And they, I think, successfully do that. I just have to say that, as we saw here, much of these documents are written with a specific country in mind. But in my view, I think it's crucial to shape the regulatory framework in a way to be able to tackle any such practice anywhere in the world. What we really need is universal framework that governs the field. And I would say there is some evidence of such emerging framework, but I would say that the regulation of this space is really in its infancy, which allows for abuses. So I just wanted briefly to look at, for instance, 4 practices that these documents address, which go on a scale of severity, I would say. So the first would be violations of the principle of consent after donor death. The second one is voluntary sale of organs coerced under economic duress. And then we have organ trafficking and trafficking persons for the purpose of organ removal, which is quite important to distinguish, but we are not going to go into that in more detail in law. And finally, forced organ harvesting that amounts to crimes against humanity. So what's really, I think, critical here is with regards to each of these practices to answer which laws govern them, who do such laws address, how are they enforced, and what are the risks for private sector who are not directly involved in such practices but benefit from them. So I've created, or initially, quite a complex table to illustrate the complexity and confusion within the legal landscape, but I'm not going to show it here because of the time pressure. I just wanted to focus on few themes. So when we speak about these practices, we need to consider what is their legal manifestation, what is their legal definition, how do we know what's prohibited? Because to tackle something, to address, to put obligation on corporations to do something, they really need to know what is legal and what is illegal and what is the gray zone. So we need to look at legal definitions, and they are lacking currently. And then we need to move on to look at the source of law. And why is that important? It's important because where do we find rules that regulate certain practices? These rules will likely determine who is a duty bearer and how do we enforce these duties that are enforced. So the report and the policy guidance highlight certain areas of human rights law, international criminal law. So it's really important to explain to non-lawyers, for instance, the fact that human rights law is only indirectly addressing private sector, and there is some emerging field of business and human rights, but it's really important to highlight, I would cite here the commentary to the UN guiding principles, which makes clear that legal obligations are found elsewhere, not in the guiding principles. So I quote at 14, the commentary that was published on 21st March 2011, that the responsibility of business enterprises to respect human rights is distinct from issues of legal liability and enforcement, which remain defined largely by national law provisions. So this is important to acknowledge if we want to say, how do we then make, regulate this space? What is needed to put in place in order to prevent those practices? And then the report speaks at length, as Ewain mentioned, about domestic criminal laws. But again, these apply, unlike human rights law, directly to individuals and legal persons. But it's a quite high threshold of liability. And distant relationship might not pass the muster. And when you talk about international criminal law, again, I think it's really important to outline what is the potential liability for corporations for crimes against humanity. And at the moment, I think this discussion is largely academic. And I'm not sure even, and that brings me to my last point, that we should be focusing so much on criminalization. I think what is missing is regulation, regulating the sector. And there is a good example, for instance, of the Council of Europe Convention on Organ Trafficking, but we only have 13 ratifications so far. So there is a clear and pressing need for regulation that governs the field, sets clear standards and expectations and protocols that need to be followed. And in that way, it would capture both those, I don't know how Wayne said, softer risks, and those more extreme that the focus, the reports and policy guidance mainly focus on. And with that, I would finish. I just wanted to say that I would invite people when reading documents like this to just think of 4 divisions between ethical versus legal responsibility, between soft and hard law. What is it, the guidance? Is it a firm obligation? To think between the law as it is now and the law we would like to see, but it's not yet there. We need to acknowledge that, and to think of the distinction between criminalization and regulation. So thank you so much for your time, and I'm happy to answer any questions.
Thank you so much, Maria. I'm sure that's going to spark lots of debate. Penelope, would you like to say some words now? Thank you.
Thanks very much, Ellie, and thanks both to Natalia and Maria. Can I just begin by acknowledging the traditional owners of the land around Australia and pay my respects to their elders past, present and emerging. In my particular case, I pay my respects to the Palawa people of Lutruwita, which some of you may know as Tasmania. I think it's really important for us to discuss to have this kind of forensic analysis of the law. Will the law in each of our nations do the job that we want it to do? This is an ongoing debate in human rights law. As Natalia pointed out, Australia does have a Modern Slavery Act. We do outlaw trafficking in organs, but there are some gaps and limitations in the way we do it. And there's questions about whether the penalties attached to that framework would be sufficient to deter people from doing some of the actions that we think would have been highlighted in the advisory. Just for the international audience, of course, Australians must remind you all that we do not have recognition of human rights at the federal level, which does impact the way in which our law is interpreted in this nation. Saying that, several states do have human rights legislation, but it's certainly not uniform. But because of the difficulties in the legal framework, I would say that it is absolutely more important that we turn to the United Nations Principles for Business and Human Rights and turn to the framework of human rights due diligence to encourage parties and individual stakeholders to look towards the issues that are raised in this advisory. In a place like Australia, where we have highly regulated lawful organ transplants, some people will be very surprised to even hear about the international trade. So it's very important to raise that. But I think that this is our experience with the Modern Slavery Act, which is relatively new, as Natalia said, but it is mirrored in the UK, that while companies and institutions might engage in human rights due diligence reporting, they often have a limited or narrow idea of what might be the required content of those reports. So it is really important to raise this kind of awareness about the human rights issues that may impact on players in the transplant industry. I think that the Global Rights Advisory is a real call out for universities and academy. Academy has not been engaging in the kind of human rights diligence that we may need. We are the educators of doctors, of allied health professionals, nurses, radiographers, all kinds of people. We are the educators of international students in Australia. We are the educators of the Asia Pacific region to a large extent. So we can play a huge role in understanding the human rights at stake in the industry and working out and thinking through what would be the kind of requirements that we would want to see in human rights due diligence reporting from the academic sector. Of course, the universities are in a wonderful position to have lots of human rights experts within their ranks who could assist them with working out what that framework should look like. But human rights due diligence, and our difficulty in Australia is I don't think there is a deep understanding of many of the content of human rights laws and what they mean in practice on the ground, particularly in health and human rights kind of frameworks. And that what we really need to encourage is a deeper engagement with the principles of human rights so that we can understand human rights due diligence in its full sense it is a far more deeper engagement that would be required by due diligence in a commercial law sense. And so we need to encourage that throughout Australia. Here in the advisory, we have a huge amount of evidence to allow us to start that debate and really encourage the human rights engagement that we need. So thanks very much, Ellie.
Thank you so much, Penelope, and to everyone. Lots has just been said. Just from me, it's really great that you all broadly support the advisory, and you've all got lots of ideas about how to take it forward, and that's exactly what we wanted to achieve in commissioning it. We're doing okay for time, so perhaps the panelists, if you'd like to answer each other's points, because I could see that there are lots of nods and perhaps people jotting things down. So does anyone want to say anything in relation to someone else's comments?
I'll say, sorry, go on, Natalia, I can see you going. You go first.
No, you go first. I think it's only right that Wayne, you go first, actually, in response to our brief commentaries.
Okay, great, thank you. I think one point I'd just like to address is, I think one of the themes which seemed to run through the panelists was the idea that we should not just be overly focused on the criminal, and I completely agree with that. And I hope that the advisory and the policy, I mean, what we were trying to achieve with them was to, of course, in one sense, to highlight the biggest dangers, which ought to be and require criminal enforcement. On the other hand, I think we, the authors, were certainly of the view that, as Penelope put it, what we needed to encourage was deeper engagement with human rights as a whole within the industry. Of course, through the UN guiding principles. I mean, what was striking to us as we conducted the research was and I use the word complacency, but I think that's rather a kind description of what we found within the industry. There isn't a culture of engagement with human rights more generally. There is a sense that within the industry we found that because we're the medical, because we're saving lives, because we are looking after people, then these human rights risks are something to do with somebody else. And so there isn't within the industry any attempt to understand the UN guiding principles, or even putting them aside, or any attempt to really conduct any minimal inquiry into relationships or activities. So I think we all came to the view that this was going to be an essential part of increasing awareness and also better practice, was to try to explain in layperson's terms what steps the industry should be taking to regulate themselves. And I was genuinely shocked. I think we all were genuinely shocked how complacent the industry is. So I think the UN guiding principles has to be at the forefront of this struggle, I think.
Thanks, Wayne. Anybody else?
If I can, sorry, Maria, do you want to go first? Okay, right. Yeah, just very briefly on that point, because again, from practical point of view, I see the advisory being a very important, very practical tool to the industry. And first of all, raising awareness, because working in the field for many years and also working on the advisory group on modern slavery to the New Zealand government, I can attest that actually the understanding of this issue or abuses, illegal organ transplantation, organ tourism, etc., is almost unknown, even by the legislator. You would kind of expect this to be a little bit but they understood a topic, which is not. So it's definitely that if anything, that's a first starting point, and I think that advisory does that excellent, in the sense that it really raises the issue and it puts it in very practical, if not pragmatic, matters as to what can be done and how can be done, looking for the red flags, and then what the industry can do to address those issues on a daily basis. Now, very briefly on something that has been raised on a number of occasions, so criminalizing generally anything in relation to human trafficking, it's always a little bit problematic, and especially when we're talking about the context of businesses, because businesses tend to respond better with collaboration partnerships rather than sticking out the stick and saying because you're going to be legally liable, potentially also criminally. But even what I said earlier in terms of the regulation of organ transplantation in Australia, I do believe that even though we have strong laws, they are currently inadequate to protect trafficking in human organs, both domestically and internationally. Having said that, there are limitations of a criminal response to organ trafficking for a very simple reason, because there is a global organ crisis, and there are basically organ shortages. So that it's a question of supply and demand. So by simply saying we have to criminalize or we need more laws in place, it's not going to solve the problem really on the ground. So it's about those different approaches and looking how we can shift the understanding, to raise the understanding, and the shift the how businesses, how any entities, because that would apply also to public entities, how they identify what the potential risk might be in this context with the tissue cells or organs they're using or relying on. So I think it's definitely it's a multi-layered and approach to it, and criminalizing is one aspect of it, but definitely should not be the only aspect. And so therefore, whether we're going through the law or law supports the understanding and implementation of principles, guiding principles, UN guiding principles on business in human rights, they go hand in hand rather than one or the other. And I think that that's really what's been happening in the field in relation to other aspects or other forms of modern slavery as well. But I'll leave it there, and I believe Maria wanted to respond.
Hi, thank you. I actually just wanted to respond to now what you have also said. So I agree with Wayne when he says there, and I mean, I don't know that, but I trust, because the report illustrates that there is a huge complacency. Now, whether it is for industry to regulate itself, I have no faith in it. When I said more laws, I don't say more criminal laws. Laws that regulate practices. So, and I think organ transplantation is not very unique here. Generally, there is lack of regulation in other aspects of medical industry. So, for instance, recently I came across something interesting about IVF. That is, for instance, hugely unregulated, and there are huge ethical issues around there. There are practices where doctors in clinics use their own sperm to inseminate clients. There are practices where doctors put 12 embryos in a woman, even though the guidelines, the professional guidelines say not more than, and it's not regulated when they are called out, when they are eventually put on trial. And that again is criminal law. There is nothing really much illegal going on there. So I think regulation means setting clear expectations. And just to answer to the question from the audience of distinguished Professor Richard Piotrowicz, whom I recognize here, I think this would not maybe change policies that China does, but it will isolate them. If the rest of the world subscribes to the same set of guidance and principles, which are made law, they will not, their hands will be bound, they will not be able to engage because they will be liable potentially for breaching those protocols, maybe financially, not criminally. I don't know what's the best way of doing it, but I think it will definitely isolate. What I think when I read this, I was looking what governs this space, and I think very little rules, clear rules govern this space. So that was my point. I definitely am not calling for more criminalization. Thank you.
Let me just say at one point, if I can, that having said what I said about the UN guiding principles, I think there is growing evidence within the field that criminal law can and does work in this, as Maria's just said, this unregulated space. If you look, for example, at the Philippines and Israel, previously, the Philippines was a place where many Westerners went to purchase organs, and the Philippines passed criminal law provisions that prohibited organ donations to foreigners. And on the other side, Israel used to be a country where many citizens went from Israel to, for example, the Philippines to buy organs. And in 2008, they decriminalized the traveling of individuals to other countries to procure organs. And as a consequence, you can see after a few years, there's been a very much a drop in the number of organs being sold in the Philippines, and a dramatic fall in transplant tourism as a whole in that country. And of course, in Israel, I think you also see a corresponding huge fall in the number of individuals traveling to procure organs. So I think because it is so unregulated, there's still a lot of space for criminal law to play their part, I think, in regulating this industry.
Okay, Penelope, feel free.
Thank you, and I think that's a really interesting discussion about the role of criminal law, and we do need laws that address the problems that we're going to address, and we need to do the research that says what are the effects of this law when you implement it this way. So we know how to stop transplant tourism. That's the way to do that. We need to think how we stop the other forms and the complicity with the illegal activity. We need to be much more astute and careful about our analysis of the law and what we do with it. And we do have to have a national analysis of that detail in every instance. I'm sorry, Maria, IVF is highly regulated in Australia. So, everybody's laws are different. It is one of the challenges of being a legal academic, that you have to deal across all sorts of jurisdictions. But we need to put the expertise in place so we know what laws work in what instances and what effect they will have. We must pay attention to implementation of laws. We must pay attention to interpretation of laws. But this is the expertise that we can bring to the field.
Thank you, Penelope. I think we'll open it to the floor now because time's tight. So I have from RYP law professor, too many prosecutors and judges are unaware of the NP principle or how it should be applied. But the UK lost a big case on this in Strasbourg about 18 months ago. Does anyone want to comment on that?
Did we hear from the question? I'm not aware of the Strasbourg case. Sorry, Natalia. Yeah. Again.
No. I wanted to answer, but I think it's a good. I think it's a good idea. Richard, if you wouldn't mind.
Okay, I'll just try to unmute. I hope you can hear me.
We can.
I made the Strasbourg in response to the point put by KF. I'm sorry, KF. I'm looking for your name. I do apologise. It's a bit early in the day for me. I haven't had a drink yet. The point is that when the non-punishment principle came up, and I've been working on this for longer than I care to remember. The point I was making is that it is still a major problem in some countries, in some jurisdictions, and I can't speak for Australia. I've been away from Australia for too long, but it's a big issue still in Europe. There's much more awareness in the United Kingdom of it now. The case I was referring to there was one brought against the UK for the first time in about 2011. It shows you how fast Strasbourg works. It's almost as slow as the International Court of Justice. And it only got decided in about, I think it was the spring of last year. And the UK was found to be in breach of Article 4 of the European Convention of Human Rights, i.e. prohibition on slavery, forced labour and servitude, and therefore trafficking, because of its failure to apply the non-punishment principle to, I think there were 3 different cases, 3 different people who had been penalised, although they had been trafficked, and should not have been penalised because their offences were directly linked to the fact that they had been trafficked. So that was the whole point about it. And I'm not sure how much that fits in with what you have been discussing here this evening or this morning, but it was a response to the previous comment from Kanish Latiman. I apologize if I have mispronounced that. But that's what I was getting at.
Yeah, is it okay, Ali, if I
Of course.
provide
Thank you. Yeah.
a response to it? Yeah. So the issue of the issue really here is that most legal instruments in this space, they don't really make a clear distinction between organ sellers and organ suppliers. And as I said, in some countries, it is illegal to sell organs, even if they are your own. But if you look into the actual prosecution statistics, from my understanding, not many actually people who sell or attempt to sell their own organs are prosecuted for it. So even though the law exists, it might not necessarily be enforced in those instances. So if we're talking about them being victims, but I suspect it could be a question of recipients, because who is actually in this case victim here, right? Is the recipient in a sense a victim of the global crisis, and let's say they do travel overseas to purchase an organ, which, as I said, under Australian law, that would not be considered to be an offence of organ trafficking, because under the definition, no one has been moved to, from, or within Australia. Some countries have attempted, Canada including, have attempted to criminalise those who would travel to purchase organs, whether legally or illegally, outside of their own jurisdiction. So we're talking about the introduction of extraterritorial jurisdictional criminalization. Now, whether that's fair approach, obviously from a moral point of view, we might say it's probably not. Is it something that is going to prevent people from traveling? Probably not. Not necessarily so. But there's another issue that we touched on, the global shortage, or the matter of supply and demand in this case. But also there is a divide between those with high, so recipients are usually those from high income countries, and donors or suppliers are usually from low income countries. So obviously the issue is not and only simply about regulating organ transplantation industry as such, but a much wider systemic issue of poverty, and that pushes people to sell their own organs. Or there have been many cases in relation to, for example, migrant smuggling, where in order for them to move to, let's say, to Europe, they on the route they had to sell their organs in order to pay the smugglers to continue on the route. So obviously, there's a much more complex than just simply saying the industry needs to regulate itself. Obviously, we do need change the culture of how industry, as Wayne has said, has not regulated itself, and therefore what can be done to ensure that the industry is become better regulated, whether self-regulated or through mandatory approaches. But also we cannot forget that this is a part of a much bigger problem, which is obviously in relation to the root causes, that is the organ shortages, and also it is according and along the lines of poverty, the poverty line. So obviously this definitely is beyond what the advisory could have done, and this is beyond our potential conversation today, but I think it's important to highlight it, that the inequalities in terms of wealth also drives the practice of who becomes a seller, who becomes a donor, and who becomes a recipient, whether that's within national level or internationally. So it's a little bit longish response to Richard's question, but I think the identification who is actually a victim and non-punishment of victims, it potentially could be even more complex depending on how we identify who is a victim within this context.
Yeah, and may I just add to what you've just said, which the exact statistics I forget, but we're talking about the average purchaser having an average income of around $50,000 a year, and the average donor having one of about $500 per year. So the inequality is absolutely massive. And the donors are not just poor, they are the poorest. So I think it's really an important departure point to think when thinking about these issues.
Thanks so much. We've got a hand up from Khanij Fatima. Please, if you can unmute yourself, feel free to ask a question or comment. Thank you.
Hey, hello everyone. I'm doing research on human trafficking, and recently I finished fieldwork on organ trafficking, basically in Bangladesh. So that's why I asked that question, because I found there is still confusion about the definition of trafficking of human beings for organ removal and organ trafficking, and also confusion about illegal organ transplant. So, and also I found gaps in international law, because trafficking protocol is not enough to define organ trafficking. On the other hand, we can see European Convention, but that is not open for the third world countries, who are mostly source countries, like Bangladesh, Pakistan, India, and other Southeast Asian countries. So, we have another problem is we have Transplant Act to prohibit illegal organ transplant. On the other hand, we have Human Trafficking Act. So something like penalize organ trafficking. So my background is I was judge in Bangladesh, so magistrate. So I found it's difficult to understand the difference between organ removal and also organ trafficking. And recently I did field work. Basically the victim was, all of them are criminals. Why? Because they sold their organ. But where this sold the organ, basically their consent was compromised, and that is vulnerability to trafficking. That's my understanding, because they are not, yes, they are selling because they want money. But why? That is one of the ground of, or I can say one of the causes of human trafficking. So it's still, confusion when the legal institutions are confused about the law and how they will implement that. And international, I think that is also the international responsibility to look at that we should have some hard law, not the soft instrument like WHO guiding principle. That is not enough, to make accountable the recipient countries, and also to figure out the state responsibility of the source countries. So yeah, that is yeah, I found this, and it's really, I'm really glad to be here, because I heard something I'm doing research, so you are doing a great job. Thank you.
Thanks so much. Maria, were you keen to say something to that? Are you nodding along, or anybody else?
No, I agree. I'm grateful that the participant, sorry, I didn't catch your name, but I agree with everything you've said. And I think making these distinctions, being clear, and that's not really easy to do. We need to acknowledge that. Can we draw a watertight line between organ trafficking and trafficking for organ harvesting, but it's important, because it's hard to go down, it's difficult to go down on companies and medical profession hard if we haven't clarified these things. So yeah, I don't have much else to say. And I do believe that voluntary guidance, they're very good. We can use them for advocacy. We can keep talking about that, can knocking on doors. But, you know, if we look at, for instance, regulation around corruption, corporations take that extremely seriously in their transnational operation. Corruption, it raises red flags in every multinational or anything. They have procedures, they know what to need to look, which red flags to look for and what is prohibited. So I cannot understand, and this is now beyond organ transplantation, why similar standards cannot be adopted for the host of human rights in which companies can be implicated. So I am not a big fan of voluntary and soft law because companies can choose to ignore them when it suits them.
I'm happy to respond to it, Ellie.
Please do, Natalia. Thank you.
Or Wayne would like to. Yeah, I mean, in terms of speaking as a lawyer, I always say law is only as good as its implementation, and we do have a problem generally at international level, international law with enforcement of the law. So if we were to rely just simply on the letter of law, we probably wouldn't go far. But law is important because it clarifies obligations, and it clarifies what needs to be done, what should be done, whether that and often how we judge effectiveness of the law is not exclusively but whether you know, how many prosecutions we have, but whether actually there is a change within a society, or in this case amongst the corporations and how they behave. And I think that even though UN guiding principles are obviously not legally binding, there have over the years, I think there's enough evidence to say that they have had an impact in the sense that many companies have changed the ways they do it. And as Wayne mentioned in the advisory, one of those suggestions is to start with the policies. And obviously having a policy, corporate policy on what to do and how to do things, it's not in itself enough. Those policies need to be implemented, they need to be followed, but also obviously unless you have a policy as starting point, it's highly unlikely that the businesses will act accordingly. Now, in terms of the wider conversation, it's something, and hence I use the example at the very beginning, because if we just simply focus on trafficking persons for the purpose of organ removal, so that is regulated under human trafficking legislation, then we are gonna miss out on the other aspects of organ trafficking that we covered, which is organ trafficking obviously covers the trafficking of persons for organ removal, but also tourism, trafficking tourism, and trafficking of organs, tissues, and cells, which is much wider. But I highlighted that even when you have specific national legislation at this stage in relation to New South Wales, the Tissue Act, which prohibits trading in tissue, then that in itself becomes a little more problematic when we start applying to transnationally or to operations, business operations that happen across different countries. So the extraterritorial jurisdiction or the application of domestic law has its limitations as well. So I definitely agree with what's been said so far, that we do need to utilize what we already have and look into what else could be put in place. And just very briefly, since 2014 at the UN level, there have been negotiations around UN Convention on Businesses, which would be legally binding. But again, at the international level, as it happens, those conventions, those hard laws, they take time. There's a question whether that's ever going to materialize. And if it is going to materialize, what is the final product, if you like? What is the actual final legal act that we're going to see there? And is it going to be significantly watered down, that it is possible. Therefore, I'm going to go back to my initial point saying that yes, law is important, and also clarity of the law is critical, especially when we talking about criminalizing certain activities. But at the same time, I think we need to think in parallel as to how change behavior of the industry, of those within the industry and the general public, because something that Richard also pointed out, people often, those individuals, recipients, do not know when they purchase organ in this context and where it comes from, or they simply don't care. And therefore, raising awareness, education of the general public about also the risks of doing transplants abroad. And obviously, we're talking about highly desperate people. This is not something, we're not talking about buying a new pair of shoes, I'm going to go abroad. This is the desperation pushes people to go abroad to have transplantations, but there are high risk health risks in relation to those transplantations for various reasons, because the way they've been performed, or maybe because they're not gonna receive full documentation as to where the organ comes from, etc., etc. And so when they return to their home country, then they might not be follow up to the same extent with a doctoral help and support. So there are a lot of issues that arise around those issues, and so none of those necessarily are the fix, but at the same time, I think we need to look into it collectively and what can and should be done in terms of regulating the industry and also raising the understanding of the dangers, obviously not only to the donors, but also to the recipients. Thank you.
Thanks so much. We are overrunning. Does anybody else have any other comments, or if anyone needs to dash off, feel free. We can stay on afterwards. If some of GRC and Nina and I can stay on after if anyone's got any other questions as well. Otherwise, we can wrap up. Okay, well, thank you so much, everyone. Really, really, really grateful to have you. That was an excellent debate. Thank you for your work in exposing these crimes, as well as making meaningful steps for change. Thank you, and we'll see you soon. Thank you very much.
Thank you, everybody.
Thank you, everyone. Thank you.
Thank you very much. Nice to meet you all.
And you.
Thank
And
you.
you.
Bye-bye.